So most, if not all, construction contracts are time barred in a sense as that the contractor shall deliver the contracted works or services within the agreed date. If the contractor fails to do so, the contractor is in breach of contract, and therefore the employer may be entitled to recover liquidated damages or any remedy expressly provided in the contract. However, if the contractor at any point in the performance of the contract was disrupted or prevented by the employer or by events which are beyond its control, the contractor may be entitled to extension of time. This section will explore and discuss the legal basis for the extension of time and its legal underpinnings under the issues and other issues surrounding time for extension. So extension of time clauses are indeed important as they preserve the rights of the employer to recover liquidated damages and enable the contractor to be informed of their financial exposure when delays occur. First, you have to establish when claiming for extension of time is the factual basis. The contractor has an implied obligation to bring the contracted works to completion without delay, meaning within the contract period. Therefore, if the contractor is interrupted or the contractor must be compensated with time or money or both, provided that the delay was not caused by them. This is the first burden that the contractor must overcome for them to be entitled to extension of time. The delaying event is not attributable to them. Proof of the delay or proof of the event occurring must be documented and shall be included in the submission of notice or claim. The second, uh, the second burden that the contractor must overcome is the establishment of the legal basis. So while the right to extension of time is in the contract, it is not automatically given. Therefore, if the contractor deems the delay incurred are excusable, meaning not caused by them, the contractor must reserve its right to extension of time by following the procedures set forth in the contract, such as submission of notices in the prescribed form, clearly identifying the entitlement, and including all information and substantiation within the time bar. Most contracts provide a duty to mitigate as a condition precedent to the entitlement for extension of time. So you have to also prove that you have mitigated and have no choice after doing mitigation measures that you still will be delayed. And then finally, the third burden and the probably the most difficult burden to overcome is proving that you have been delayed. So this is what we call the delay analysis. For the contractor to be entitled to an extension of time, the contractor must prove that the event which has occurred has caused them delay. There are several delay analysis procedures to determine the effect or the lack thereof of an event. Delay analysis will also lead the determination, the delay analysis will also lead to the determination of the quantum of the delay in terms of days, months, etc., and the cost that comes along with it, such as loss and expense and other damages that are due under the contract and under the law. So what if the contract does not have an extension of time procedure or does not have an extension of time mechanism? Then we consider that the contract is at large. So as mentioned earlier in the slides, construction contracts are time barred in a sense that they must be performed and completed within the agreed period. But what if the contract does not contain such mechanism? So the contract enters a state that we call time at large. So when the contract is set at large, the time is no longer binding on on the contractor. So time is deemed to have been at large when the agreed completion date expires and that there is no mechanism in the contract that allows for extension, or when the mechanism in the contract has broken down and becomes unenforceable. So what is the effect? So the effect of the time being set at large is that The contractor is released from its obligation to complete the project within the agreed period, and the contractor is instead allowed to complete the project within a reasonable time. Furthermore, when the time is at large, the employer can no longer recover liquidated damages from the contractor arising from its failure to complete the project within the agreed time. So we've been discussing extension of time uh, in the previous slides, but who has the power who is entitled or who is empowered to extend the time? So in standard forms of contract, it is the contract administrator who is empowered to extend the time for completion. The standard building contract gives the contract administrator the power to adjust the completion date of the contract in cases where relevant events occur which delayed the contractor from performing his obligations, such as natural causes and acts of men. The contract administrator, upon receipt of notice from the contractor of the delay or occurrence of a relevant event, the contractor shall notify the contract administrator of such event, and the contract administrator will then reply within reasonable time before the expiry of the time bar. So while the contract administrator has the discretion in granting the extension, the arbitrator or the court may intervene in circumstances where an allegation of bias or inequity in the decision is present. This was the position of the court in the case of John Barker versus London Portman, where the court held in that case that that the court or an arbitral tribunal may open and review the decisions of the contract administrator when the mechanism provided for in the contract has broken down, or when the application of the provisions of the contract are incorrectly applied or interpreted in a man which resulted in a manner that is biased to one party and therefore not fair. So what are the delaying events? So I have classified the delaying events into three categories. So delaying events or events which were caused by the employer, which delaying events which were caused by nature, and other events which cannot be classified under employer and nature. So among the risks or among the delaying events caused by the employer is failure to give possession to the site to the contractor, failure to issue information in a timely manner, defaults on payment, suspension of the works, instructions relating to variations and provisional sum, uh, uh, delaying events which are of natural causes are exceptionally adverse weather conditions, natural catastrophes, force majeure, and epidemics which may result in movement control or restrictions. Other events are changes in legislation, civil commotions such as wars, terrorism, and strikes, and shortage in manpower or labor, and changes in statutory requirements. So, as you can see, the current pandemic, there the delaying event of the caused by or the pandemic being a delaying event is not necessarily under the contract. However, the the circumstances or the events resulting out of the pandemic may qualify the contractor